Guys, good morning. Make sure everybody has the cameras on, please. Hey, Millie, good morning. See, got Marta, first one always. Got Juan, got Danny, Raphelia, Alexis, I see you there. Tiana's there too. Hey, Tiana. We have Lula, Tiana, and Baby. Great. We have Sanady. There you go. Hey, hi, Baby. Baby's gonna join the class. Okay, cool. All right, whoever's watching on YouTube besides Millie, good morning to you all. If you have any questions, drop them in the chat as you go, in the live YouTube chat. And Zoomers, you're always welcome to ask questions. Glad I checked my phone. I didn't put on mute. Okay. All right, so today's chapter, it's only one chapter, chapter 21. And this chapter, we're going to divide it in two as well. It's a very long chapter, and it's a very comprehensive chapter. So I need you guys to, as usual, pay attention to it. If you have any questions, you stop me at any time, and I'll explain all over again. Not a problem with that, okay? All right, so closings. Who can tell me what a closing is? Start with a question right away. Who can tell me what a closing is? When you finalize a sale. Yep, so another word for this is settlement, right? When we settle the transaction. Settlement, when we settle the transaction, right? So we finalize the sale. We're done, right? We finish. We are done with transaction. Okay? And why is it important for you to know all these words, right? Settlement equals closing. Closing equals settlement. Because we talked about this before in financing, which we're going to repeat all over today, which is the Real Estate Settlement Procedures Act, RESPA. You guys remember RESPA? You heard about RESPA before? Say yes. I know it's too early, but say yes. You've heard about RESPA before? Okay, cool. But yeah, it's the Real Estate Settlement Procedures Act. So when you see settlement, we're talking about closings, right? It's at the time of closing. So from beginning to end, what must we do, right? As salespeople, what must lenders do? The obligations are set forth here in the RESPA, the Real Estate Settlement Procedures Act, okay? We're going to talk about the financial settlement of the transaction. We're going to talk about computing prorations, which are the adjustments between the seller and the buyer, and I'll explain all that as we go. Taxes due at closing. We're going to briefly go over that. State exam usually does not talk about the taxes due at closing, because a lot of them, they vary from state to state as well. Closing cost calculations. We're going to go over a case study, a lengthy case study, for you guys to understand if it was a real transaction. So we're going to navigate through a real transaction for you guys to understand how the calculations are made. We're going to briefly go over TRID, which is the TILA and RESPA Integrated Disclosure Rule. And then reporting requirements is how we're going to finish. All right. So let's start with the closing event. By the way, guys, what happens at closing? Let me know. What happens at closing? We finalize the sale, we got that, but what happens at closing? What is the event? What do we finalize? What occurs after that or during that? Let me know. YouTubers, Zoomers, let me know. What's the answer here? Too many signatures, yeah. So many that Juan even cuts it in half. Look, you got signats. There's no signatures. It's signats. That's it. That's the new word, right? You just went Cardi B on me. You created a new word. That signat right there. There you go. What else? That's how new words happen. It's like that. Somebody makes a mistake or a shortcut, and that's it. I swear I'm gonna go to a closing and do that. I want to see your signat right there. That's it. Even Tiana's baby's laughing. Anybody else? What happens at closing? Only Juan answers? Talks about the signature? Come on. Okay, the buyer pays and signature and paper, tile. Whoa. Okay, all right, fine. I'll figure out what you're saying there. Buyer pays and signature, paper, title. Okay. Then he says you sign and get the key. Great. Then he says we've earned to get paid. Okay. Juan says get the keys. All right, what else? Anybody else? Yeah, these are all valid, but there's one thing you guys forgot. We mentioned in financing. Oh, you remember now. Good. You get in debt. Great. So close to that. All right. So it's very close to that. So three things happen here. The most important are the first two, right? And the least important. And the least important. Your credit drops, really? And the least important is the third one, but I'm going to explain. The first two is the actual closing of the loan, right? I'm going to explain that in a second. It's the closing of the loan. That means money's transferred from the lender to the escrow agent, which is whoever's closing, right? The escrow agent. The second thing, once the money's there, we have the clear to close, so we're good to go. And that means that we can now transfer the title, get the keys. And yes, that's when everybody signs. Correct. All right? And then the third thing that happens, guys, and this is why closings are so important for you to understand. The third thing that happens is if everybody's happy, if the transaction concluded, we, salespeople, like Danny said, we collect what we've earned over the time. So 3 events happen at the closing. It's the closing of the loan, it's the actual closing, and us collecting our well-deserved pay. That's what it is. All right, so you think it's important for us to know what happens all the way to a closing and even at the closing? Right? We're not the ones preparing anything there, but yes, we should know how to go through a closing. Okay? All right, so let's go over this. So the closing event is the culmination of the real estate transactions, the peak point of a real estate transaction. During this event, the buyer pays the purchase price and receives title to the purchased real estate. At the same time, the buyer completes financing arrangements, and then buyer and seller pay all required taxes, fees, and charges. Sorry. Now, customary practices, procedures, and customary practices for conducting real estate closings vary from state to state. For example, it is common in some states for sellers to pay title insurance. In other states, the buyer pays for title insurance. In other states, there might be a share. So right here it says share. So we need to know in each state what is the general rule. There's nothing wrong with most of the times. There's a general rule where, let's say the seller pays and buyer says, no, 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 I want to share that expense with you. Or no, I'll pay for you. If it's going to make the deal sweeter, it's called negotiations, right? But some states are standard that the seller will pay. Other states they share. And in some states, the buyer pays for it all, okay? Time. The sales contract sets the date of closing, usually within 60 days of signing, and the time period between signing and closing is expected to be sufficient for the removal of contingencies. What are contingencies? They're conditions. For instance, I'll buy your house as long as I obtain financing. So contingencies, you guys remember, are conditions. Okay? I'll explain that in a second, Sinead. I'll get there. Performance of inspections. I'll buy your house if the inspection is satisfactory. And correction of identified physical defects. So there's damages to the house. Can you please fix this in order for us to move forward? Okay. Failure of either the buyer or seller to perform pre-closing actions specified in the contract can delay or even terminate the transaction. If the contract includes a statement that time is of the essence, right? Time is of the essence, then all parties agree to meet time limitations exactly as stated. If both parties consent, however, they can reschedule the closing date. So a time is of the essence, or as we commonly call TOEs, and one of our realtors became very familiar with TOEs. Unfortunately, we are during the pandemic, a lot of things change and a lot of delays, and some agents are overwhelmed, some attorneys are overwhelmed, some appraisers are overwhelmed, so things delay. Mortgage companies are overwhelmed, things delay. So when things delay, one of the parties is going to issue what's called a time is of the essence, or a TOE that says, hey, we should have closed on X date, right? Your client is in default if we don't close by this date. Therefore, my client can walk away, say goodbye, walk away from the transaction with no penalties, because we set the date, right, to 60 days from signing. And now we're still waiting something to happen, right? So we could clearly walk away. Location. Where do we close, guys? Well, wherever we agree. It could be at the office of the title company, the lender, the escrow agent, one of the attorneys, the broker, or even the county recorder. Anywhere. Okay? The sales contract will specify the location. Parties at closing. So who must be at closing? Technically, the buyer and the seller. That's it. Do we have to be at closing? No. So the primary parties at closing normally are the buyer, the seller, and the closing agent or the escrow officer, whoever is effecting the closing, right? Other parties who might be present include the title officer, attorneys, brokers or agents, and the lender's rep. Now, I did say that we don't have to be there. My question is, do you think you should be there? Like, we don't have to. Not a requirement at all. Do you think you should be there? Okay. All right. The answer is yes. You should be there because it's your client. That's number one. Second, collect your check. Let's see if you understand. I've been saying this from the beginning of this chapter. There's three things that happen. There's a closing of the loan. There's the actual closing. And I told you the least important of all is your payment, right? So I put in order again. You should be there because it's your client and also because you want to collect your check. Money is secondary. You'll get your money no matter what. If it closes, you'll get the money. If not that day, the next day. But that support, beginning to end, is key to building relationships, right? Everlasting relationships. You close with that client, they're so satisfied that you were there even at the end, right? That they will refer. At least that's what you expect, all right? Don't be one of those agents. The reason why I mentioned money last, there are some agents that show up and say, hey, where's my check? And that's all they show up for. You get to the closing, your client's right there, and you walk in just to get your check and walk out. All right? If you want to be that type of agent, go ahead. You're not going to get many referrals. That's how it is. People will see you for who you are at the end. Okay. Hey Rose, good morning. How are you? All right, the closing process itself. Closing process. So the closing process consists of the buyer and seller verifying that each has fulfilled the terms of the sales contract. If they have, then the mortgage loan, if any, is closed. All expenses are apportioned, and paid. The considerations exchanged for the title. Final documents are signed, and arrangements are made to record the transaction according to local laws. So, again, very simply, we confirm performance. That means everybody did what they were supposed to do. We close on the loan, so the money is transferred to the escrow account. We appropriate the money to pay the expenses, whoever needs to get paid in the transaction. We exchange the funds for the title, and then we complete and sign the documents. And usually, not required, but usually we record the whole transaction. Okay, remember, recording is not required. But usually that's one of the things that happens. We record a transaction. All right. So the seller must produce evidence of marketable title, such as a commitment for title insurance by a title insurer. And before making a title commitment, the title company performs a title search to discover any liens, encumbrances, restrictions, conditions, and easements attached to the title. Guys, let's talk about this real quick. Quick recap. What is a lien? Who remembers what a lien is? What is a lien? Let me know in the chat. Okay. Great. So yes, a lien, for some of you that wrote this, a lien is some type of encumbrance. Yes, perfect. Tiana was stressing, like she wrote encumber, right? And then she was like, why didn't he stop there? Because I had the right answer. Like, I kept on like looking at it. Bruno, my answer is there, right? Anyway, but like Juan wrote as well in Sineti, it's also based on a financial claim or money owed. But it's a type of encumbrance. See, all liens are encumbrances, but not all encumbrances are liens. What does this mean? Well, it simply means that encumbrance, which is a cloud, don't worry, Rose. Spelling doesn't matter. As long as you know what it is, it's fine. Except for Danny, because you write Bauer instead of borrower. Anyway. By the way, Danny, 10 years from now, I'm still going to mess with you on that one. Right? And wait until I see your brother. All right. So, the encumbrance is a cloud. So, it's something that attaches to your property and slows down the progress of your property. Meaning, if you want to sell the property, you need to resolve the cloud first. So, take over, pay off the lien or any other encumbrance before you can pass it along to somebody else. So, encumbrances could be physical or it could be a lien. Right? Physical encumbrances is a party wall, right? It's a shared driveway. You guys remember this? Those are physical encumbrances. Like, for instance, restrictions is a physical encumbrance. Could be a physical encumbrance. Conditions, depending on what the condition is. Easements are physical encumbrances. Licenses, encroachments, these are usually physical encumbrances. All right, so it was just a quick recap from the first week. Now, if there are any encumbrances or liens that damage or cloud the title, right, the seller is expected to remove these prior to the date specified in the contract. The most common title cloud is an unpaid lien, like a mortgage, or taxes, like Who wrote taxes? Joel wrote taxes. Yeah. So that's the most common title cloud or encumbrance, an unpaid lien. All right. Now, the seller is also asked to execute an affidavit of title. And this affidavit of title, if you ever see it, affidavit of title, states that since the date of the original title search, so since the first time we checked it till now, the seller has incurred no new liens, judgments, unpaid bills or repairs or improvements, no unrecorded deeds or contracts, no bankruptcy or divorces that could affect the title, or any other defects that the seller is aware of. So I, the seller, promise, I swear and I subscribe, so I'm going to sign on it. I swear and I subscribe that none of these happened and that the buyer is going to have a clear title according to the things we agreed to. So there's nothing that was hidden. There's no new things that will pop up that I'm aware of, right? And I swear and subscribe. What does that mean? It means that through this affidavit, the title company and the buyer now gain the position to potentially sue the seller if these are false. That's pretty much what it is. Another thing we have here is a buyer walkthrough. And this is simple. All right, a few things we're going to go really fast. This is simple. Walkthrough. Should we do a final walkthrough? Should the buyer, right before the closing, right, go through a final inspection of the property? Let me know. What do you think? Should there be a final inspection of the property? The answer is yes. Great. Why? Question now is why. You want to make sure nothing is missed? Like what? What would you miss? You want to make sure nothing was removed? Everything that's on the contract, like what? Make sure nothing was removed, right? Make sure that all agreed on is still there. Make sure everything is okay with the house. All right, so fixtures, great. So looking at your answers, let me just pop them here in the screen. Looking at your answers, here's what we got so far. So you want to make sure that nothing is missed, that everything's that's on the contract. Make sure all agreed on is still there. Make sure nothing was removed. Make sure everything is okay with the house, like fixtures, for instance. Yes. All right, so all these are correct. You want to do a final walkthrough because when you first saw the property, when you second saw the property, even when you third saw the property, right, there was people there. There was, meaning somebody was living there. There was furniture, right? You want to make sure that everything you guys agreed on contract to stay, like appliances, fixtures, right? You want to make sure that they're there. But not only that, like Clenard said, you want to make sure everything's okay with the house. So when the furniture gets out of the way, you want to make sure there's not a manhole, right behind the furniture. You want to make sure they were not hiding anything. So you want to make sure that the walls are intact, right? That the everything is the way it was supposed to be. What do you do if there is? What if there's a manhole there? That's when we go to negotiations at closing. So that's why it's so important to do a final walkthrough, because you don't close without agreeing, hey, there's a manhole over there. It's going to cost roughly $1,000 to fix. I want a credit of $1,000 on my account right now. So before we close, attorneys will resolve to issue a credit towards the closing. So the buyer will receive a credit to fix any final issues that were not seen before. That's what it is. Okay? All right, the next thing is, if you have a lien, a mortgage lien, for instance, or any type of lien, we need to pay it off. That means we need to call every single lender or every single creditor or every single lien holder, right? And these are different, right? We need to call all of them for a payoff. Now, why am I saying they're different? Because a lien holder could be a judgment, could be a lawsuit, right? A creditor is usually, for instance, a mortgage company. But it could be also any other financing that you obtained against the property, or that the property was included as collateral, right? So payoff statement is what we need to request. And that payoff statement is going to include the final number. It's going to, of unpaid principal. It's going to include interest due by the time of the closing date, plus any fees that are due to the lender, any credits or penalties that may apply, and so on. Okay? So payoff statement, very important. All right? For broker's role. At the bottom of page 321, broker's role. What do we do? Well, usually, depending on the state that you're in, right? The broker usually continues to provide services between the signing of the sales contract and the closing to make arrangements for pre-closing activities such as inspections, surveys, appraisals, repairs, and generally taking steps to ensure that the closing can proceed as scheduled. When I say depending on the state you're in, is because some states, they force you to be there all the way to the closing. Other states are a little bit liberal with those rules, where it's kind of like, hey, you showed up at the end, you can show up in the beginning, you can show up at the end if you want, right? And of course, it also depends on the type of representation you're giving. If you're a transaction broker, you're going to be there, but there's some limitation to what you're going to do for your client, or how much support you're going to give for your client. You still should know these things. You should still help with the arrangements, but there are limitations, again, depending on the type of relationship you have, whether you're a sales agent or a transaction broker. A broker may conduct proceedings at the closing meeting or may have no further role in the transaction after the sale contract is signed, like I said, depending on local practices and the transaction in question. In many states, the broker is charged with the responsibility for accuracy and timely delivery of the closing documents to the principal parties. And a broker may also have the responsibility, usually does not happen for us brokers or salespeople, I mean the brokerage side of it, right? That's what I meant. Usually title company or anybody else will report to IRS. All right, so attorneys or title companies usually do that. In any event, doesn't matter what your role is. Let's think about this logically. If your state does not require you to do so, right? We're going to think about this logically. You have to think that your clients are your babies, right? Would you let your baby cross the street by himself or herself, right? You want your baby to grow. You want your baby to succeed, right? You want to close. That's pretty much what we're looking for, right? So why would you abandon your baby, right? And a lot of realtors, like I said, they do this. They abandon the babies and then they show up, hey, did you graduate? Right? Like, hey, where's my check? You don't want that. Make sure you guys walk your client through every step. There's nothing wrong with getting assistance, right? There's things like transaction coordinators, right? For instance, inside sales agents. There's so many quality control. There's so many types of supports, administrative support that we can have in the office, or you can hire on your own. But regardless of that, don't just abandon the baby. You can say we work as a team, and you're going to have calls from this person or that person, sure. But I'm going to check with you along the way, so I'll make sure that everything goes smooth. Simple. All right. Right here. Finally, if the seller of the property is a non-resident alien, the U.S. law may require the broker to withhold and transmit to the IRS a portion of the sales proceeds to cover alien seller's income tax liability. And there's also special reporting requirements when the transaction involves non-resident aliens. With that being said, about non-resident aliens, are we required to request proof of citizenship or proof of residency uh, from the buyer? Are we required to do that? What do you guys think? Because this might be a question in the state exam. What do you guys think? Are we required to do so? Then they decide yourself. No, yes. Can I get a maybe? And the answer is, drum roll. The answer is, we are required to check the client's financial ability. That's it. If the client, the bank will, okay? So, hold on. Juan says no, but you would only get a loan. What do you mean? Because here's the thing. Can I buy property in another country? Can another country buy property in the US? The answer is yes. You could be a non-resident alien, right? You can buy properties. The question is, do we need to verify or require proof of citizenship or residency? The answer is no. We're not required to do so. We're not even required to ask for IDs. The bank will. We are not required to do it ourselves. Our requirement is to make sure that the buyer is able to buy. That means get me that pre-approval. That's it. All right? If you're a resident or not, that doesn't stop you from buying. You can invest in any country in the world, provided that the laws over there allow you to do so, right? You can invest anywhere. Heck, there's people selling spaces or spots in the moon or even in Mars. So, anywhere in the universe, technically. As long as you got the money or the financial ability, you're approved. You guys understand? We're not required, and we cannot require proof of residency. If you tell me you are a citizen, I have to believe you. If you tell me you are a legal resident, I have to believe you. If I tell you you're not a resident, I have to believe you. We cannot request that type of information. The bank will request all this information. Okay? I can ask you, so Sinead just wrote, when I purchased my house, they asked me for the ID. Who did? The realtor? Okay. If the realtor did, we can request for an ID, so make sure you are who you say you are in terms of person. But what I'm trying to say, I'm not your employer. I'm not required, okay, I see your ID, show me proof that you're a US citizen, because this ID looks fake. Right? We're not going to run it to any database. That's what I'm trying to say. We don't run through any database. So Nady, stay with me, please, just once. Stay with me. I'm answering you directly. It's tough when you guys are home. Jesus. Tough. Aha. So Nady just wrote, when I was getting the pre-approval. So yes, did the realtor require it or did the mortgage require it? See, for banking purposes, guys, for banking purposes, they have to verify that information. But that's the lender. We're talking about realtors. We're talking about salespeople, broker salespeople, or the brokers. This might be a question in the exam. As salespeople, our job is sales. It's not to verify somebody's residency. As long as you qualify, our job is to sell. If the mortgage company lend money to you, banking laws require them to verify IDs. That's a different story, okay? But not us. Now, with that being said, we are not required, right? We are not required. The question is, should we? Okay, I'm gonna put it like this. I have you'll understand my question here. I have a buyer right now who's also a seller. So he's selling his house and he's buying a house, right? Obviously, usually that's what happens, or they go rent, right? So the first thing I did when I talked to the seller was, hey, let me know if there's anything here in the house that I need to know about. Right? We asked a bunch of questions. One of the things he did, he finished the whole basement, right? And I asked, did you do this? Did you get permits? Right? That's the first thing. So before even listing, I'm asking these questions because I want to see the paperwork even before listing. Not like some realtors that they just list and then, yeah, they have a finished basement. No, I don't know if the city approved it or not. And then the whole transaction goes down the drain because it's not an approved finished basement. All right, so you have to ask these things up front. Some people get so excited. I'm going to sign a contract. I'm going to get my first listing, my second listing, my 10th listing. Some people just care about signing a document and then moving forward, right? And then you guys remember the toes? Time is of the essence. Those will pop up because we're pending so many things that were not provided up front, right? The other thing is, Danny, it's a different scenario. I'll explain that in a second. So the other thing is, for him as a buyer, before I even started showing houses, which he was very excited, hey, let me go see houses, let me go see houses. One of the things I requested was for him to get pre-approved, right? Before the agent, the loan officer got there, right? Before they got into the meeting, right? One of the things that we did was request right away all the documentation that the loan officer would require. So this goes with having a good relationship with loan officers and say, hey, this is the scenario. The person has this type of income. The spouse has this type of income. What do you need? So in this case, my seller / buyer, he's on disability, right? So he receives disability income. And the loan officer asked me, okay, if it's on a disability income, then I need this award letter for disability, right? This is a yearly letter that goes out that says, hey, for next year, this is what you're going to receive. It's an award letter, right? So point of this whole thing is, before I hand over the client to someone else, and before I actually handle the client in terms of listing or buying, I'm prepping the client to provide me all the information needed. So then once we're under contract, whether it's for a listing or under contract for a purchase, right? I don't have to rush back and forth to try to figure out where this document is, where that document is. No, let's do it now before anything else. Are you guys understand this? I can guarantee you, if you guys get everything out of the way up front, I can guarantee you that 90% of the times you will close, right? Because everything is out of the way. But if you're finding things along the way, right? There's a chance that it takes a little longer, and there's a chance that the potential buyer for your listing will not be able to buy anymore because there's a time lapse between their pre-approval and the actual closing. Are you guys understanding? Right? So asking information up front, it's not required, right? It's not requirements, but why not? Oh, you're a non-resident? Great. You have your tax ID? That's one of the things, right? Oh, you're a legal resident? Do you mind if I get a copy of your ID? We're going to need this, we're going to need that. Or make sure you have it ready for the loan officer. Right? We're not required to do so, right? But why not? Are you guys understand this? Right? Be ready before anything else. Danny, so am I a disclosed dual agent? No, because I don't represent the buyer for the seller. I represent the seller on the sale, and then later on, I'm going to represent the buyer on the buy, or vice versa, doing at the same time. So I represent the same person, just in two different capacities. That's what I'm trying to say, right? If I find a buyer for his house, if I find the buyer, then yes, it'll be a disclosed dual agent because I have to disclose, hey, seller, I found you a buyer. Hey, buyer, this happens to be my listing, right? So if they're okay with it, we move forward. If I find a seller for my buyer, so if I find a house and I list the house for my buyer, then yes, the same thing. Okay? So you only a disclosal agent when you represent both parties. In my scenario, I'm representing the seller for the sale, and the seller is going to become the buyer, or buyer first and then sell. It's going to become the buyer for the purchase. So it's the same person. I'm in two different capacities. Rose, I got your message. Thank you. Okay. So, what's next? RESPA. This should be quick because you guys should remember RESPA, right? What is RESPA all about, guys? Who can tell me? What is RESPA all about? I was going to start singing a Bob Marley song, but I only have two birds out the window. Bob Marley had three, so I can't do it. So, what is RESPA? Who can tell me? YouTubers, I see there's 5 people watching. If you have questions, let me know. Anybody? Let's see, Settlement Act. Great, because that's what it says, Settlement Act. I appreciate that. Or Ophelia says Consumer Protection. Close. Leonard says all steps to closing. It's in there as well. Okay. All right, Joel, let me know on that. Develop on that, Joel. Say to show the seller and the buyer's settlement cost. What does settlement cost mean? Guys, what is a settlement cost? Joel is right. That's the answer. What is the Real Estate Settlement Procedures Act? What is it about? Right? It's about, exactly, so between Clenard and Joel, we got the answers. So besides all the steps to closing, the required stuff to close, right? It also addresses what's very important, which is the closing costs that the buyer and the seller must be aware of. So every time you guys see RESPA, or Real Estate Settlement Procedures Act, one, it gives you the procedures to close, settle the steps, right? And also, very important, everybody must be aware of the costs. Okay? So RESPA, the main purpose is to clarify the settlement costs or closing costs, because settlement means closing. Again, closing. You guys should remember this. We talked about it in chapter 17. So only 4 chapters ago, right? But you should remember this, that RESPA applies when you're dealing with residential property. So that's a 1 to 4 family residence, including co-ops and condos, right? Right here, it involves a first and or second mortgage lien. And if it's being financed by a federally related mortgage loan, which includes loans made by federally insured lender, like VA, FHA, loans administered by HUD, or even loans intended to be sold to Fannie Mae, Freddie Mac, and Ginnie Mae. You guys remember these names, right? Fannie Mae, Freddie Mac, Ginnie Mae. Great. So any loan that involves a federally related transaction, any loan that's a first or second mortgage lien for the purchase of residential property must comply with RESPA. That's what it is. Okay. Now, RESPA was a completely independent act as of 1974, but then on October 3rd of 2015, RESPA merged with TILA. Guys, what is TILA? TILA, who can tell me? It's an 80, Truth in Lending Act. Perfect. So what is a TILA for? What is a Truth in Lending Act for? Let me know. To protect elders and creditors? Okay. They go hand in hand. Elders and creditors. I understand. To protect lenders and creditors. Close. Close. TILA. What is TILA for? Danny says for the costs and terms. Great. For what? Costs and terms. Great. So TILA is for costs and terms. What does that mean? Okay. Loans and financial, consumers. Whew. You guys is like pulling teeth. Unbelievable. Okay, okay. Courtney says, notifying the loan recipients of what they look for in order to get loan the money. All right, so all right. So here's what we got. TILA. Let me help you guys. If RESPA is for closing costs, so let the buyer and the seller know the costs of closing, right? TILA is for the loan costs. All right, just like who was it that wrote this? Danny. All right, so just like Danny wrote, and now Joel as well, and Courtney. In other words, let me clarify. It's to let the buyer know of the potential costs of the loan, right? So TILA is the Truth in Lending Act, right? It's to let the buyer know the true costs of financing so they can shop around for different lenders. Okay? They can shop around for different lenders. That's what it is. Both of them are for the consumers. So yes, 180, great. But develop a little bit more, guys. It's for the consumers to be aware of the loan costs and the closing costs. Now, before, used to be two separate types of disclosures and even a third disclosure for the loan. So a bunch of disclosures, bunch of forms, right? And as of October 3rd, 2015, they merged all these forms. They merged all these forms into one, which is now the TRID. It's the TILA and RESPA integrated disclosure, integrated disclosures. Okay. So now instead of having a good faith estimate and the HUD-1 settlement plus the TILA disclosure, which was a third document just for information, right? So good faith estimate is, hey, these are the numbers. The HUD-1 is, hey, these are your final numbers or projected final numbers for settlement, right? And then a separate document which talks about loans. So three pieces of documentation were available back in the day, right? Now they merged the forms into two forms that we now call LE, if you guys remember LE or loan estimates, right? And CD, which is closing disclosure. LE and CD. So at the beginning, these forms were merged into one to estimate the loan and potential closing costs all the way, right? And then at closing, right before the closing, they have to give you the same form, but now called CD, which is a closing disclosure, CD. Okay. A lender subject to RESPA must give the loan applicants also the Consumer Financial Protection Bureau booklet, which is your home loan toolkit, and it must give that to you within 3. I don't know why none of these publishers do this. Within 3 business days of receiving a complete loan application. This booklet describes loans, closing costs, and a closing disclosure form. Okay? Everything is going to be in this booklet to get you ready for the actual closing. A lender must give the applicant, at the time of application or within 3 business days, now it says 3 business days, they must give you a loan estimate, or LE, of the likely settlement costs for both the closing and the loan. The estimate is usually based on comparable transactions completed in the area, and the terms stated in a closing disclosure must agree with those of the loan estimate within certain limits. Under the CFB rule, you guys already know this because we covered in Chapter 17, a lender must use the closing disclosure to disclose settlement costs to the buyer. This form covers all the costs that the buyer will have to pay at closing, whether to the lender or other parties. Use of this form enforces RESPA's prohibition against the lenders requiring a buyer to deposit excessive amount in the tax insurance escrow account, or to use a particular title company for title insurance. The consumer must receive the completed form no later than 3 business days before closing. No later than 3 business days before closing. And you have the right to inspect the revised form at least 1 business day before closing. Okay, so quick recap before we move forward. The LE, or loan estimate, must be given to the borrower within 3 business days of application, of completed application, right? And then at least 3 business days before we actually close, they must give you the CD. So 3 business days from application, and then at least 3 business days before closing, the CD. Okay? All right. Referral fees and kickbacks. It says right here, RESPA prohibits payments of fees as part of a real estate settlement when no service was actually rendered. So if I refer a borrower to a lender, the lender cannot pay me, hey, thank you for this borrower. Nope, cannot happen. If a lender refers a buyer to me and I find a house and we close, I cannot pay the lender either. Those are called kickbacks or referral fees. And that's prohibited under Section 8 of RESPA. Okay. You guys good so far? Give me some thumbs up. There you go. All right. See some thumbs up. Good. Now, here's what we got. It says the process of settlement consists in 5 basic steps. Identifying the selling terms and closing costs. So pretty much what we agreed to in the contract, right? Determine non-prorated debits and credits. Determine prorated debits and credits. Complete the closing statement and then disperse funds. Okay? So non-prorated means expenses only. Prorated means we're going to give money to the seller or to the buyer. So one party gives money to the other or vice versa. And I'm going to explain that as we go. So the selling terms and the closing costs, like I said, it's what's written here, is the price of the property, the buyer's deposit, down payment, all the terms and amounts of the buyer, financing arrangements, and so on, closing costs. All these are called terms, okay, closing terms. This is where we're going to spend some time over the next couple pages. We're going to talk about debits and credits. A debit is a minus, okay, in your account. A credit, it's a plus in your account. So debits is something like you guys can see that if you check your statements when you purchase something. And by the way, this is very important for you guys to understand. There's a question of math that I can almost guarantee it's going to be there, where you don't even need a calculator. You just need to understand debits and credits. All right. So let me address this real quick. If you go to the supermarket, right? Let's go with the logic. If you go to the supermarket and you swipe your card to pay something, first of all, who's the seller? Supermarket, right? Who's the buyer? You are, right? So if you swipe the card, you paid $102, let's say at the supermarket, $102. On your bank account is going to show what? It's going to show minus $102, correct? On the seller's bank account is going to show what? Plus 102. So what I want you to understand about debits and credits in terms of prorations, adjustments, right? You're going to have a bunch of questions and we're going to go over this today. What I want you to know is simply that whatever you take from one side, you give to the other. So if you see something that talks about prorations, right? And don't worry, we're going to go over this in a second. Just repeating it again. But if you see something in the exam about prorations, about adjustments, how much will the buyer get if the seller did not pay for taxes yet? Or how much should the seller get if they prepay the taxes? Very simple. You need to understand what prepayment means, what unpaid means, or arrears, right? And for that, once you understand that, then you'll know who gets the debit, who gets the credit. So it's a matter of logic. And then once you understand what unpaid or arrears mean, now you're going to look for the answer that has the exact same amount. Because like I said, when you swipe the card, it'll be minus 102 on one side, it'll be plus 102 on the other. And if there's a refund, guess what? It's the reverse. That's why adjustments and prorations are so important. And it's not that hard. It's literally a matter of you guys knowing who gets the prepaid amount or who gets the unpaid amount, and look for the answer that has the same exact amounts for either or. Okay? So again, a debit is an amount that a party must pay. A credit is an amount that a party must receive. So the excess of buyer's debits over the buyer's credits is the amount that the buyer must bring to the closing. The excess of the seller's credits over the seller's debits is the amount that the seller will receive at closing. Now, an individual expense item that one party owes to a party unrelated to the transaction, like an attorney or the state, is treated as a debit to that party only. So individual expense to a party that's unrelated to the transaction is called, it's a non-prorated item. It's an expense only, right? A prorated item is treated as a debit to one party and a credit to the other for the same amount. Same amount. So if it's an expense, that's it. It's a minus only. Like attorney fees, right? Expense, it's a minus only. If it's prorated, something that's owed to the buyer or owed to the seller, then it's adjusted between them, right? And it's the same amount, taken from one side, given to the other. Let's talk about the buyer side, credits and debits. So let's start with credits. So credits, as you guys know, these are pluses, things that enter the closing statement as a plus. Enter the closing statement as a plus. And what do we have? Earnest money. What is earnest money? Good faith deposits, right? So the good faith deposit we gave up front, right? Up front. So if we already gave it up front, and it must go towards the closing at the end, right? So in the closing statement, it's a plus. It's going to enter the buyer's side as a plus because we had already paid, right? The loan amount borrowed or assumed. The loan is going to be a plus for us because the bank is dropping the money into our account, right? Technically, it goes into the escrow account, but it shows as a plus on our end, the loan amount. And then the seller's share of prorated items that the buyer will pay. So if the seller owes you money for a particular item, like prepaid, unpaid taxes or unpaid water bill, unpaid sewer bill, whatever it is, right? There will be a plus for the buyer. Now, what is considered a minus for the buyer? The purchase price. See, we received the loan, but then we have to disperse the payment, right, for the purchase price. So it's a plus the loan, but it's a minus on the full purchase price. Also, other expenses, which are based on the agreement or custom, right? And then if the buyer owes money to the seller, like prepaid taxes, the buyer owes money to the seller, then there will be a minus on the buyer's side. For the seller's side, the debits on the seller side are the expenses like attorney fees or a title company if it's the seller paying. Expenses would be recording stuff, for instance, like a release of the deed or mortgage or anything like that will be an expense, right? The seller's share of prorated items that the buyer will pay, so whatever the seller has to give to the buyer is a debit. And then the loan balance or other lien to be paid off. See, if I still have a loan balance, I receive a plus, which is the purchase price, right? I receive the plus, but I have to pay off the balance, so this is a minus. I still owe $100,000. I received $400,000 for my house, but I still owe $100,000 to Bank of America, so I have to pay off Bank of America. It's a minus. So we get a plus purchase price because it comes from the buyer, and then we get a plus from the buyer's share of prorated items. So anything that I prepaid, the buyer must credit me. All right? Pretty simple so far, right, guys? We're good? All right? Kinda? All right, questions? Ask me questions before I move forward. Diana just goes like, questions? No, I'm good. I'm good. That's fun. All right. Again, ask questions if you have to. All right. As I said, non-prorated items, these are costs incurred by one party only. Non-prorated are costs incurred by one party only. These are things that the buyer usually pays or things that the seller usually pays. Keyword, by the way, guys, keyword is usually. Like I said, depends on local customs. So it could be, sorry. So it could be negotiated as well. So it's either local custom or it could be negotiated between the buyer and the seller. But usually, nationwide, this is what's expected. That the buyer pays for mortgage recording fees because it's a new mortgage, right? Documentary stamp tax, intangible tax on mortgage, mortgage-related fees like appraisal, credit survey, loan, impound reserves or insurance taxes, which are insurance and taxes. So the word impound also means escrow. So if you see these, I mentioned already in the previous chapter. Okay, impound, reserves, that's insurance and taxes. And attorney fees. And then the seller pays the pretty much the realty transfer fee or stamp tax on the deed. Title insurance, brokerage fee, inspection fees, title-related expenses, and attorney fees. So I want to stop you right there and point out that not every state requires a seller. I mentioned earlier, I'm mentioning again, not every state requires a seller to pay for title insurance. In some states, usually the buyer does that. So when we get to the state portion, I will point that out. Guys, I have to keep on repeating. It's only for 4 hours. It's tough to get your guys' attention for the 4 hours, huh? Unless it's an emergency, guys. Unless it's an emergency, there's no reason. Unless it's an emergency, there's no reason for people to cut in and out or for you to be distracted. Same. Okay? That being said, I hope I don't see you again here. That's what I'm trying. I'm trying to kick you guys out. You don't understand that? I'm trying to kick you guys out of this class. That's what it is. All right. Items paid in advance. Guys, let's talk about prorations. Items paid in advance. These are things that the seller prepaid. So if you see something that was paid in advance, seller prepaid. If the seller prepaid, right, that means that the buyer must reimburse the seller. Buyer must reimburse the seller. Okay. If it's paid in arrears, that means unpaid. Okay, so prepaid, that means the seller already paid, therefore the buyer must reimburse the seller. If it's unpaid, then the buyer is the one that receives the credit. So the seller is the one that must give money to the buyer. All right. There's something called charging shares. Okay? So charging shares is sharing the expense. So the proration has a charging share. So how much is the buyer's share? How much is the seller's share? That's what we're looking at. Okay. All right, we got 7 people watching on YouTube. Guys, if you have questions, please feel free to stop me and say, Bruno, please explain. Right? Zoomers, the same thing. I'll keep on saying this. Stop me at any time, okay? So charging shares. Let's look at this. Let's assume that we had a closing on August 7th. Closing on August 7th. Before I say anything else, if we had a closing on August 7th, right, we're on the 7th day of August, there's still how many days left, right? Anybody knows how many days we have left in August? Let's see if you guys are with me. Let me know in the chat how many days we have left in August. $24 days. All right. So, as August goes all the way to 31. So there's 24 days, right? So did we use, let's start with that. Did we use the full month? As a buyer, right? As a buyer, did we use the full month? As a seller, did we use the full month? The answer is no, because we're closing on the 7th. Okay? The answer is no, because we're closing on the 7th. Right? So we need to adjust. For instance, prepaid taxes. If the seller already paid the taxes for the year, as an example, they paid the taxes for the year. Well, from the 8th and on, that's the buyer's share. That means that the buyer must reimburse the seller for the amount that was unearned, so that or unused by the seller, right? It was unearned by the buyer and unused by the seller. So from the 8th of August till the 31st, plus September, October, November, and December, right? These are unearned fees. Therefore, the buyer must give that amount, whatever it might be, we're going to go over an example in a second, must give that amount to the seller. If it's a monthly expense, like for instance the rent, the seller already received the rent, or the buyer will receive the rent. Either way, if the seller already received the rent, then the seller must give to the buyer days 8 through 31. Okay, so must give 24 days of rent to the buyer. So that means we need to divide that monthly, divide by daily, right? Figure out daily, right? And give that amount to the buyer, or vice versa. If the buyer will collect later, then the buyer must give 7 days of rent, worth of rent, to the seller. Because again, it's unearned money. The buyer came after, from the 8th and on. You guys with me so far? Great, awesome. So there's two methods for computing prorations. There's a 30-day method, which is the 360, 12-month 30-day, which is a 360-day method. And there's a calendar day, which is the 365. So this we call accounting method. And we call this calendar. Because for accounting purposes, to make things simple when you go to do accounting, like financing, right? We're going to look at 12 months in the year, and let's make it even, 30 days each. Make it even. So that's 12 times 30 is 360. But we all know that calendar days, we have 365. So there's going to be a slight difference between one and the other. Okay, slight difference between one and the other. So we're going to go over the 360-day first. Pay attention, guys. 360-day first. We're going to identify, first thing, for annual items, we're going to identify the total amount to be prorated. Total amount to be prorated. So if it's the taxes, let's say it's we're going to have a number in a second. But let's say it's $2,000 worth of taxes for the year. Great. We're going to divide that amount by 12, right? And we're going to reach what's called the average monthly rate. It's not the exact rate because we're not using the actual number of days. We're using the accounting method, which is 360, right? We're going to divide that by 30 to reach the average daily rate. Once we reach the average daily rate, we multiply that amount times the seller's number of months of ownership in the year of the sale up to the month of closing. And for the month of closing, we multiply the seller's number of days of ownership times the daily amount and add the results of the previous result. The final result is the seller's prorated share of this item, and then the buyer's prorated share of the item is the total amount minus the seller's. For the monthly, and I'm going to show you numbers in a second. I'm just briefly going over this. For the monthly, we identified the monthly amount. So the rent is $1,000 a month, the rent, right? We're going to divide that by 30 to obtain the average daily amount. And then we multiply by the seller's number of days of ownership. So 7 days, if you guys remember. So we figure out the daily, multiply by 7, and that's how much the seller gets. And the difference between the $1,000 and those 7 days is how much the buyer gets, or vice versa. Right? Let's look at an actual example real quick. It's always easier to have actual numbers than it is to just read the text, right? Let's go in an actual example of the 360-day method. By the way, in the school exam or in the state exam, it will say using the 365-day method or using the 360-day method. So they'll be very clear on using this method or the one we're going to talk about later. Right? So, good morning, Ruth. Good to know that you're there. For your comments. All right, so a sales transaction on a single-family house closes on March 2nd. March 2nd. So this is the stuff you need to extract from the question. We close on March 2nd. County taxes for the previous year to be paid in arrears amounts to $1,730. So we closed on March 2nd. The taxes for the year is $1,730. The seller owns the house through the day of the closing. So that means that on the 2nd, the seller still pays for the taxes or still responsible for the taxes. So the buyer is only responsible from the 3rd and on, right? What are the sellers? This could be a question. What are the sellers and buyers' prorated shares of this item? All right? Usually the question is simple. Usually the question is simply who gets what, right? And they give you 4 options. And again, in this case, it's paid in arrears. So that's another thing to remember. Paid in arrears. That means unpaid. Right? If it was prepaid, it would say, hey, seller already paid. So these are the things we need to figure out from the question. Closing, March 2nd. Amount, $1,730. And then paid in arrears. I'm going to show you in a second how none of this math matters, right? You need to know how to calculate it if they ask you a specific question. But if they're asking who gets what, I'm going to show you how none of this matters. You only need 2 items here. That's it. Ready? So it says right here, sorry. It says right here, total amount due is $1,730. That's the total taxes due. Using the 360-day method, right? The monthly amount, we're going to divide by 12. So this is called the average monthly rate. Average monthly rate, as we said before. Now, we're going to figure out the seller's share by calculating the daily amount, okay? So that means we divide by 30. And that's the average daily rate, right? How many days was the seller there? The closing was on March 2nd. So he was there for 2 days of that month, correct? For 2 days. And the reason why I'm doing this, if you guys figure out for that month versus going by month first, is because was he there for the whole month of March? No, he was there for 2 days. So can we use March as the monthly rate? No, we can only use January and February. So they were there for 2 months and 2 days. So considering the amounts, this is the monthly responsibility plus the daily responsibility. This will be the total of the seller's share. The seller needs to receive $297.96, right? So how much does the buyer receive? How much is their share, depending on unpaid or prepaid? How much is their share? Well, their share is the total amount minus the seller's share. Says that the buyer's responsibility, so this is seller, this is buyer. The buyer's responsibility on the taxes is $1,432.04. Okay. Now, closing statements. How would we see this in the closing statement? Well, simple. Because it says that it was paid in arrears, that means it's unpaid, right? So the seller will be charged. If it's unpaid, the seller will be charged the $297. Okay? So this means seller, buyer. This means minus 297.96 plus 297.96. Debits and credits. Debits and credits. So was this amount needed, the 1,432? Do we need this? Well, we only would need the 1,432 if this said prepaid. If it said prepaid, then how much credit would the seller get? Then instead of 297, without any math, you would look for the answer that said plus to the seller minus to the buyer, because if it was prepaid, that means the seller already paid and needs to be credited, right? And do we need to calculate all that stuff? The answer is no. We're going to look for the answer that has the same exact amounts. In this case, is 1,432.4. 1,432.04. So technically, guys, what we need to learn is who gets what. If it's prepaid, seller gets it. If it's unpaid, the buyer gets it. And then the amounts are exactly the same. Okay, so write this down somewhere. If it's prepaid, seller gets it. If it's unpaid, buyer gets it. Got it? Thumbs up. If anybody has questions, YouTubers, Zoomers, if you have questions, let me know. Any questions, let me know. Okay, so in this example, this is where we get buyer, the seller will be charged because it's unpaid, so it's minus, and the buyer will be credited. Next example is if we're talking about a monthly item. So in this example, still March 2nd, same example, is just now they're asking for the rents. This example, the rent is $1,800 a month. Okay. Look what it says. The month of March was already paid to the seller on March 1st. So that means the seller already received it. Okay. If the seller already received it, then what does the buyer get? That's the question. What is the buyer's prorated share? How much do they get, right? Well, it's easy. Based on the 360-day method, it doesn't matter if it's 31 days, if it's 29, it does not matter. We're going to divide it by 30. And it says that it's $60 per day. Because it's 2 days that the seller was there, right? The seller only gets $120. The rest of the amount is owed to the buyer. So in this example, the seller will be charged, because they already collected the rent, the seller will be charged $1,680. So again, seller, buyer, minus $1,680. plus 1,680. So always the same amount. All right. If the buyer receives the rent later on, then it will be the opposite. Then it will be minus 120 for the buyer, plus 120 for the seller. So always the same amount. Just look at who's going to be charged. If it's prepaid or unpaid, who's going to be charged with it? Who's going to be debited or who's going to be credited? So Nady, if we're using the 360-day method, then all the months are equal. It's 12 months of 30 days. Okay? If we're using the 365-day method or 366, depending on the year, right? Then we have the actual number of days. So yes, at this point, we're going to divide by 365, or if it's a month that has 31 days, we're going to divide by 31. Or if it's a month that has 28 days, then we're going to divide by 28. So it depends on which method you are using, and I'm going to show you here the difference is about $7. It's the difference between using the 365 or the 360 method. Okay? So right here, it's the exact same example. 1,730 is the taxes. March 2nd is the closing, right? And it's paid in arrears, so unpaid. Again, unpaid, right? The total amount due is 1,760 divided by 365. So now we have what's called the actual daily rate. This is the actual daily rate. The other one was the average daily rate because it was based on 30 days instead of the actual number of days, right? Now we have a slight difference here. We're going to calculate 61 days at $4.75. Okay? So in the previous example, we had 62 days. Right? We had 62 days. This one has 61. So what's the difference? Well, the difference is now that we need to calculate January, which has 31 days. We have to calculate February, which has 28 days on average, right? And then we need to calculate March, 2 days, right? So if we add them up, this is 61. 61 days. These are the actual number of days that the seller stayed in the house for this year. So 61 actual days times $4.75 actual daily rate. That means that the seller's share is $289.14 and the buyer's share is $1,440. Exact same example, different methods of calculation. The seller will still be charged because it's unpaid, right? But they'll be charged $289. Right? I'm sorry, $289.14. Something there. So seller, buyer, minus $289.14 plus $289.14. Okay, so the one before was $296.74 or something like that. This is $289.14. So the difference, $7. Okay, just very slightly. But they will tell you in the exam which method to use. If it's the 360, then all the months are 30 days. If it's the 365, you have to calculate the actual number of days. Okay? So method, very similar. The key thing again is to know who gets the credit or who gets the debit. Is it the seller or is it the buyer? If it's prepaid, seller gets the credit. If it's unpaid, buyer gets the credit. Simple as that. Anna, that's child abuse. Saying. I saw that. All right. Sometimes I wish I would do that to you guys, like have something just like smack you. But you're on camera, just saying. This is being recorded. I will call CPS services right now. Just letting you know. I will provide the recording. Right? And we know you're in Irvington. Just saying. Send them over right now. We got all your information. You are being recorded. Anyway. I know, I'm bad. All right. You guys good? Can we take a little break? Everybody's like, yes, please. Can we take a little break? Yes? All right. So it's now 11:48. 11:48. So we're going to be back by 12. So you got 12 minutes. 12 minutes, be back at 12. YouTubers, I'm going to close this session. I'm going to open another one right after. See you guys in a bit.